Better pick a date.
Let's table it to the point where all the information is up to date, and then we can bring it back.
Until Mr. Tyler brings it back. He mentioned he wanted it tabled.
Yeah.
So I would make the assumption that when he brings it back to us, he will have gotten over his issues.
Yep.
That
So we'll
works.
just leave it open-ended based on his input.
I think you have to be date specific.
Okay? Okay, with that, we'll get to agenda item TA 14-0001, a request by Natrona County Development Department staff to consider a text amendment to the following text pertaining to natural expansion. And I think I have to turn this over to Mr. Knight.
I think we'll have the staff report really quickly, and then I'll be back.
Okay. With that, then I'll ask for a staff report.
Mr. Chairman, Commissioners, as you see in your staff report, there's proposed modifications to our language as it relates to natural expansion. And I'll defer to legal, but generally speaking, our definition of natural expansion, I'll defer to county attorney.
I'll go ahead. I'm sorry, Jason. I just wanted to the proposal is to delete Chapter 9, Section 4, and replace it with what's in your staff report.
Could you read that for us, please? The part where you're wanting to change it to?
Page 201 through 203. Non-conforming use cannot be extended, enlarged, or expanded except as provided below. As a general philosophy, NCUs are permitted until they are replaced by conforming uses. This accomplishes the goal of having compatible uses in the zone. A non-conforming use is a use which was lawful when the zoning resolution was enacted, but under the terms of the resolution is now prohibited, regulated, or restricted. The right to an NCU depends on the legally commenced non-conforming use at the time the zoning resolution was adopted. Section B, all NCUs are subject to reasonable restrictions designed to protect public health, safety, and welfare. C, an NCU is not affected by change in ownership. D, if active and continuous operations of a non-conforming use is discontinued for a period of 12 months, all subsequent uses shall be in compliance. Mr. Chairman, this is, I'm glad to read it, but it's a couple more pages. Do you want me to read all this?
I just wanted the basic, what you just did.
Okay, and I just will say that it goes on for 2 more pages, and I'm not exactly sure, having read this probably 100 times, where this section on non-conforming uses ends. The natural expansion doctrine ends. It goes through a set of criteria, and it goes on from, it could be read to go all the way through in, but I see no relationship to non-conforming to the natural expansion doctrine in any way, shape, or form regarding this. And then that's part of the reason that this was brought forward, because the language is confusing, and I'm not sure anyone knows what exactly what it means. What it is proposed to be replaced is everything would be deleted and would be replaced with, this is fairly short, so I will read it. And I'm quoting language from the 1994 zoning resolution, by the way. The definition of a non-conforming, parentheses, grandfathered use is a use which, on the effective date of this resolution, or as a result of a subsequent amendment thereto, does not conform to the permitted or conditional uses established for the district in which the non-conforming use is located. Where at the effective date of adoption or amendment of this resolution, a lawful use exists that is no longer permissible under the terms of the resolution as adopted or amended, such use may be continued subject to the following provisions. If active and continuous operation, if use is discontinued for a period of 12 months, all subsequent uses shall be in compliance. No non-conforming use shall be expanded beyond the use in existence at the time of the resolution, and no non-conforming use shall be changed to another non-conforming use. little history here. Prior to the 2001, put this on. Prior to 2001, all the previous zoning resolutions contained this language, that a non-conforming use cannot be expanded. The term in 2001, I have no idea the basis where this came from. What Section 4 was added, it greatly expanded the non-natural expansion doctrine. It states here, recognized by many courts, allows limited expansion of a matter of right, where it says expansion extends the use contemplated at the time, is not detrimental to public welfare, and shall not violate dimensions, size. It's my opinion this is a statement that's contrary to the law. This is a much more liberal natural expansion doctrine than I have seen in any other court. And so what the purpose of this amendment is, which was brought by the county commissioners, which is to replace, remove the natural expansion doctrine, the liberal interpretation of the natural expansion doctrine, back to what Trumbull County adopted in '72 and had in effect until 1992, until this amendment was done. One thing that I expect will have comments is, well, this is an attempt to deprive someone of a non-conforming use of grandfather. And this actually it's related to it, but it absolutely is not the purpose and intent of this. A grandfather non-conforming use must occur before we ever talk about natural expansion doctrine. A grandfather use is a constitutionally recognized property right, vested property right. It's recognized by both the United States Supreme Court and the state of Wyoming and the legislature and the courts of the state of Wyoming. So it's not an issue with whether or not we have a grandfather or we're trying to limit grandfather. The question is, if you have a use that is grandfathered, a non-conforming use, can that, and then a resolution is passed prohibiting that use, can that use then expand? That is the issue here, and that's the subject of non-conforming of the natural expansion doctrine. I brought with me just a section of American Jurisprudence, which is a legal encyclopedia. I just want to read briefly here, and I'll tell you one of the differences that we have between our zoning resolution and the widely accepted zoning resolution. Some jurisdictions recognize a right to expand a non-conforming use, despite the general rule that such expansion is not permitted. Okay? So we are certainly in that exception, and we allowed it where generally it's not permitted. To allow for the natural development and growth of a non-conforming use, the right has been called a natural expansion doctrine, permits the augmentation of a non-conforming business use to meet the demands of normal growth. Then down at an observation here, it says the natural expansion doctrine is a business doctrine that has not been applied to residences. So you will not find any reference to business use in our zoning resolution. Again, I have not seen any other states or any other cases that allow this, but I'm sure this is adopted from somewhere. I will quote to the Wyoming statute 185207, which recognizes grandfathering, which we again are not trying to prohibit, but it says, a zoning resolution shall not prohibit the continuance of any use of land used at the time of adoption of this resolution, and is paraphrasing. However, the alteration or addition to any existing building or structure for the purpose affecting change in use may be regulated or prohibited by resolution. So the legislature did not provide an opportunity to expand use here. And there's no Supreme Court case in the state of Wyoming that has recognized the natural expansion doctrine. There was a case just recently out of Teton County, which almost all zoning cases are, that was close to this, and the court did not, in that case, adopt the natural expansion doctrine. It never came up. They never discussed it. It was an opportunity to do it. But I can tell you today, there is no case law in the state of Wyoming that says we recognize the natural expansion doctrine as a constitutionally protected right for people of Wyoming. So our attempt hear the Commissioner's attempt to see which brought this, is to replace the liberal interpretation of natural expansion doctrine to eliminate it and put us in line with most other jurisdictions.
Okay. Any questions for the attorney?
Could you explain that again?
I don't know if I explained it the first time.
Let me see if I can, in my mind, do this. Right, okay? I have a building. We're not, in Natrona County, we do not distinguish between business, house, home, residential, whatever. So we'll just say I have a building. And we've come in, on top of that, we put zoning regulations that I do not conform to. Okay. Today, Natrona County would allow me to expand that use on that property under the natural expansion doctrine.
Correct.
We're trying to now take that away from that particular deal to fall in line with what I think you said was in the statutes. Under the grandfathering issue that you can't go further than that. It sounds like to me in that one I'd have to really get a look at that. But we're just trying to get back to where everybody else is in terms of not letting that non-conforming use expand on that, in that particular zoning issue. That's correct. Is that correct?
You did a better job than I thought I did. But I just would like to also back to where the county was between 1972 and 2001 as well.
Okay, and we don't know where this other thing came from.
Or the reasons why.
Or why. Or why.
Mr. Chairman, a question.
Sure.
Where does the term natural come from? You know? I heard that. I thought we were talking about some kind of environmental deal.
Well, I think it's more of
Progression.
businesses naturally increasing as they grow over time, a certain right to expand that business. I don't know any more than that.
I have a couple of questions along those lines then. Are we gonna put something in there that allows what I'm gonna term as natural expansion for a business and not inhibit or prohibit them from expansion?
Well, that would be, that's not how it's proposed. You know, so if a business is located in a residential district, you know, they would not be allowed to expand.
Fill your revenue.
That, you know, that certainly could be adopted, but I think one of the issues that you have with it is when you start trying to allow it, where does you go from let's make an attempt to allow it to something that's well beyond what is. And again, this would only be a non-conforming business. So any business that's conforming, this would have no impact on them whatsoever. And I really don't know how many of those are in the county, if any, at this point.
Well, I have previous experience along those lines from years ago. There was a wrecking yard in question that the planning department took pictures of, and that wrecking yard was only half full, and that wrecking yard cycled. Now, we're talking back in the 90s. So when they took this picture, this yard was only half full. 3 months later, they went in there and this yard was full, and they wanted to come down on them with a heavy hand. But that yard cycled. And we had a big fight over that. That was inside their boundaries. And it was what I'm going to call natural expansion at the time.
Correct.
But it cycled. It went through a crusher. The yard would come down in its volume, and it would sit there, and then it would start building again until they get enough to make it profitable at that time, and they'd crush it out. That's my reference to that. The wrecking yard is no longer in existence anymore. But
No, they got rid of them.
it was there.
Is it, aren't we talking about, how do you phrase this? If I have let's say an acre, it's the wrecking yard, and I own this acre, and I'm next door to you, and it's a wrecking yard, and I expand and contract on that in my normal business activity, which would be, I would consider a normal business activity, buying junk, cars, waiting till I get enough, crush them, up and down on that acre. That acre is what we're talking about to be the non-conforming piece within, let's say, the residential area. So we're not talking about the activity that's taking place, but we're talking about the activity taking place on that land, which I just think that's different to me. Does that make sense? Aren't we? Because we have a non-conforming use on 1 acre, okay? And during my normal business cycle of, let's say, a year or 6 months or whatever, I expand and contract my junk cars, which is my business. I don't go outside that, and I don't change the business, so nobody should bother me with my non-conforming use
Correct.
at that point.
I would agree with that. But if you had 10 acres there and you only used 1,
And then I went to 5,
then you went to 5, then that would be.
then that would be something.
But I think if you
Fill it up.
over time you'd gone from the full one down to the small part, and then that would be part of your process, and that would be the way you would use it. But another example is, if you had, say, livestock in town, and you had, on 1 acre, and you had 10, and then it became an area that you couldn't have livestock, well, you couldn't expand your operation to the whole 10 acres there. You'd be restricted to what you had at the time the resolution was passed.
Now you understand the liberal in there, why it was written the way it was.
If we prohibit livestock, we may not. Prohibit livestock, I'm not sure what that is.
Okay. All right. With that, I guess it'd be all right to open this up for public comment. Okay, I'd like public input on this at this point in time. Please, anyone wishing to make a comment, please step forward, state your name and address clearly for the record.
In favor or against?
Just public comment.
Okay, I'll take the reins first. And
I'd like to add, Mr. Chairman, we did receive 1 public comment opposing it, and that was given to you, but offer that part of the record.
And by the way, in the public comment we received, there was, most of the comment was involved building codes, and this won't affect that in any way.
Hi guys, Judy Jones, 335 North 8 Mile. Let me just start with Mr. Bailey. You couldn't have nailed that any better about the planning meeting minutes. I had to go through when I was doing my court case and transcribe meetings from both Board of County Commissioners and Planning and Zoning. They are atrocious. And that's a lot of what my case was about, was the mistakes in those very things. Also, on the planning website, it's averaging 2 to 3 months behind on your minutes. And then when they're incorrect, say someone comes along and they're going to do a court case, there's no accurate record unless they were sitting here that night in video like I do. Or they buy the CD for $10 and transcribe it themselves. So you're very well, you're right on. Secondly, if the reason that they're changing this natural expansion, that was the very thing I fought my case on. And it is recognized at federal, state, and local levels. There is a case in Wyoming. It was Campbell versus Natrona County Board of County Commissioners, and it's called a vested interest in your land. Okay, say you want to put in, you've got X number of mobile homes, and you've got 10 acres there, but you only got 3 or 4 of them on it at the time. But the county suddenly says, well, you can't add anymore. Okay, his vested interest is the part where he says, I've got 3, I wanted to put 10. If you change this, he won't be able to do it. That's why I don't know whose idea this was. I have a pretty good general idea of who's behind it. And I would urge you guys to vote no, because it's not just going to be about mine and Dana's stuff when you do this. You're going to end up with another can of worms over in district court, because this is federal. So, also, do we have any other developers in this town? I mean, in fact, tomorrow night, we're doing Keith Tyler stuff again with the residents out on Salt Creek. I really feel like this is like a drive-by development, you know? Oh, there's an area, let's rezone it and upzone it and get houses in there. But when you go back by these so-called new developments, they're empty. Nobody's bought lots, nobody's built homes in them. We've got them all over the county. Secondly, you're right, Mr. Hutchinson, he should have to put a park in over there. I mean, you got 50 plus the first Riverview. There'll be 100 families in there, supposedly. Are they even going to be affordable to regular Casper people? Who knows? And you're right, all of you guys, you need a full deck of cards when you're dealing with people. Especially your developers, leaving DEQ studies out to be turned in later, you know, and all of this, you guys are correct on this. How can you make any kind of decisions without a full deck of cards? I couldn't. And final, I want to welcome you to the board. I hope you take lessons from Mr. Hutchinson and Jim Brown and Harold and Bob. You guys are getting on top of this. I'm very proud of you. And you know me. I'm not one to pass out compliments if I don't think you deserve it. But tonight I think you guys could really do us a big favor by, there was a reason they wrote it that way in 70 and kept it all the way up to 91 and then redid it in 91. There's a reason for it, and I think it's here tonight. I don't want to spend another $200,000 to hold on to my rights, or I don't want my children to have to do it either. So thank you.
Thank you. Any other public comments on this agenda item?
Paul Pad, 2781 Cherokee Lane, Casper. A couple things kind of pop out to me on this particular agenda item. When you're talking about the natural expansion, and I know we spoke about just doing, it was mentioned about doing something on 1 acre, and then Mr. Knight said, you know, if that 1 acre was just part of a 40-acre plot, for example, would you be able to expand what you were doing on that 1 acre under this change? I'm feeling the answer is going to be no. I think something that hasn't been thought of here yet, or perhaps thought of and not brought up, is that if you take somebody that has a non-conforming use on a portion of their property, what happens if they want to make an upgrade or perhaps an improvement to that part of it? Is that then going to be considered an expansion beyond the natural expansion and not allowed to even upgrade a building that's being used for this purpose? I mean, they're going to say, well, you can't change it, you can't upgrade it because now that's considered an expansion, so that's not going to be allowed. So I think we can end up looking at something with good intentions and having bad side effects down the road, and that not going to allow. Someone may want to put up like a privacy fence around whatever they're doing on their property to, you know, I don't know, because their neighbors don't want to look at it. Maybe they want to put it around it. Well, maybe they have, you know, I can use the Joneses, for example, with the, you know, older vehicles and stuff that there's, you know, that they have out there. So they block this in. Well, maybe all these vehicles are compacted into an acre, acre and a half, whatever. Well, they want to build a bigger fence around that. They don't want to put a fence just around that one little section. If they want to build it around further, now somebody's going to come in and say, well, you can't do that because that's an expansion. I mean, even though it would be for the betterment of the area, you're going to deny a betterment. I think it's going to turn into a point where you're going to end up blocking upgrades blocking improvements, all because they're trying to say that you're expanding when you're not allowed to if you go through with this. So I guess that's kind of my point on it. I think that we better really think about this long and hard before you vote on this. I would, what we have seems to have been working so far. I don't know why we're talking about changing that, but I'm really have this fear that by changing this, you're going to block some things in the future that would actually be beneficial. So, thank you.
Thank you. Public comment on this agenda item?
I'm Larry Kilwine, 9266 Trail Road, out there on North Degree Road. I was wondering how this would affect me out there. I own land from North Degree Road, roughly a mile and a quarter south along the interstate, 180 acres roughly. And I'm phasing out my drilling company, got wore out. Spent over 50 years at that. And this has been a drilling yard ever since I owned it. I pay commercial taxes out there, but they got it listed as residential and agriculture out there. And if I wanted to expand anything on my place out there, how's this going to affect me? Or if I wanted to sell it later on in life, which is probably going to happen, could the other people do anything out there?
In this case, I have to defer to Mr. Knight. I can't tell you.
I'm not sure I have enough facts to answer it, but I'll try hypothetically. If he's got an area that's been used in a certain way prior to the zoning resolution in there, that's a grandfathered parcel and it would change. But he would not be allowed to expand it. I don't know how much you're using now. Let's say you're using 10 acres and you wanted to expand your drilling yard to 480, then you would not be allowed to do that. Zoning resolution.
Somebody might want to come in and buy this place that has a big drilling company, and need more land. I would say, I don't like this idea that the way you're thinking on this, because the land would be useless. What would you do with it if he couldn't expand it, It's right on the interstate. You said the town's moving north, or the county commissioners, they were moving out on Salt Creek, and I'm just over the hill there from where it's sand pit there, and gravel pit there. It's going to be eventually turned into commercial, all use out there.
I think under that criteria, Mr. Knight, that they would come in for a zone change, and under that it would be granted.
That was my exact comment, that this doesn't prohibit the zone changes, but part of the idea behind this entire thing is zoning resolutions are enacted to protect the health, safety, and welfare of the community for that, whatever reason, whether you agree with it or not, that's the idea. And when you allow someone to continue a non-conforming use, well, they are basically an exception to the governing body that passed this zoning resolution that said, this area is only going to be for residential uses, and however, it's constitutionally protected right. If you've been there and you're doing it before, that's a taking if, in fact, you make that person remove their non-conforming use. But the question is not whether or not they can continue that non-conforming use, is do they get to expand it and use more land that contradicts the zoning resolution or not. And as
Your
your
opinion.
majority jurisdictions say,
You've been wrong before, lots.
I've got roughly 15 acres that I've used for the drilling operation there, and then the rest is agriculture. I sometimes lease it out and let people put cattle on it, and it's grazing land, but it's coming to the town is moving that way, and I'm thinking, I've been approached by different realtors that want to come out there and subdivide that and and sell it off as commercial land, you know, but I've been putting it off because I like living out there and don't really need the money to sell it right now, and would like to keep it like it is, you know, as long as I can, but I don't look for expanding any bigger than the 15 acres, but my main concern is that I sure don't want to be down the line and want to do this, you know, and then can't do it, you know.
Yep.
Now, in my opinion, as I see it, all this is, if you decided to sell it, you'd have to come in and ask for a zone change, because then it would change from agricultural to whatever you decided to do with it. And that doesn't have anything to do with this natural expansion.
Yeah, but it still should be my right, if I wanted to expand it myself, that I should be able to do it, you know. Why not leave it alone like it's been? It's been working, ain't it?
I think we're on two different subjects here, Larry.
Mr. Chairman,
Yes.
if I could add, I think the existing wording of Section 4 is quite precise of what the obligations of the non-conforming use is. The natural expansion is set forth. I found this quite clear cut.
Yep.
Personally, I don't see any reason why it needs to be substituted by something that could be construed as being a little bit more vague.
Yep.
Is that the existing resolution?
Yes, I've got it right here.
Okay.
It's all, I guess. It's like, you know, we surely don't want to get in another big court battle over, you know, stuff like this. It's, like I said before, it's wasting taxpayers' money and taking a lot of people's time and spending some of our earnings, you know, that we've worked for 50 years just to keep our stuff out there. You know, I keep my yard pretty nice and clean around there and plan on it. And, my wife blows a head gasket every time I come driving in with another car or something. But another thing is, I've still got roughly 40 vehicles that I keep licensed, you know, and pay insurance on and stuff like that. That's revenue to the county, you know. I don't see why they want to come out and change something that is going to mess that all up, you know. Thank you.
Okay, thanks, Larry.
Hi, my name is Janelle Moore. I live at 161 Indian Paintbrush. Nice to meet all of you tonight. So, I guess a little bit of my concern is I don't find it just a simple zone change that, you know, if we did adopt this, we could come in. And I'm not here to bash my county commissioners tonight, but I kind of want to give you a couple examples on my concern with that. It appeared to me that the county commissioners attacked property rights with the Joneses because they were trying to make everybody around them happy. So they were looking at the property rights of, you know, the neighbors around, or at least that's what they had said. But the confusion comes with just recently when there was a cell tower that was supposed to go up on somebody's property. They then did, you know, a 180 and said that gentleman had a right to do what he wanted on his property, and so they changed it. And didn't care that everybody else came in and was upset with it. So there just isn't a lot of consistency in some of the decisions. It seems to be hodgepodge. And so I guess that would be my concern is, you know, if I wanted to do something with my property, what kind of decision would I get from my commissioners? A second thing, and I'm not trying to be rude, but I don't appreciate working my hiney off to pay taxes so that the county can, you know, have lawsuits against people. And I do see that this probably would end up the same way. So that's all I have to say.
Okay, thank you.
Thank you.
Good evening. My name is John Stevenson, 6694 Poison Spider Road. Mr. Knight, when he was asked to read the 4, 5, 6 pages or whatever, he made a comment that he didn't even understand it. Well, he's our county attorney. He should understand it, and I'm thinking that he probably does, that there's probably an alternative motive behind him shortening the said resolution. If there is a problem with natural expanding resolution, if it's become a problem, I would like to have somebody give me several for instances of where this has happened and how frequently it's happened and how much time and effort we've had to fight the natural expansion. I think that this is a target towards the people by Mr. Knight. I don't think we need to change the resolution. I believe it's working just fine the way it is. It was written up in that language for a specific reason. And if none of us can understand it, I suggest that we either hire somebody to explain it to Mr. Knight and explain it to you and explain it to me. I don't think that there needs to be wasted any more time on this because I don't feel that it's necessary. I'm very opposed to wasting any more time, you gentlemen's time, our taxpayer dollars on this. I think it's working fine the way it is. Thank you.
Thank you, Doug. Any other public comment?
Good evening, my name is Dana Jones. I reside at 335 North 8 Mile Road. And I would like to bring up that the natural expansion doctrine has already been tested in the Trona County as recently as our court case against the Trona County Commissioners. It was decided in district court that we grew and the natural expansion doctrine did apply to us. So it's already been tested. So I agree with Mr. Brown. Why don't we leave it alone? Why do we have to revisit it? Why is this thing being done again? Why do we need to test it? Why do we need to do it? Why don't we leave it alone? It's already been tested. My suggestion is leave it alone. We do not need this amendment. Anybody have any questions? We spent a lot of money to get there, and it was decided by Mr. Solomons, and it's real and it's alive. So it's not like it's in outer space, it's some fantasy, it's real.
I want to congratulate you on your work out on 2026.
Well, thanks.
I've been by there a couple of times.
I appreciate that.
It's a work in progress, I'll tell you.
We're a work in progress and trying to make the thing work and keep everybody happy. And Jason has been a great help to us, and I want to commend his actions on that.
Thank you, Dane.
Okay, thanks, I appreciate it.
Yep. Any other public comment?
I would like to make one more addition, if I may.
One more name, please, and address, John.
John Stevenson, 6694 Poison Spider Road.
Thank you.
We're here tonight to try to protect a resolution that already has been adopted by other communities, such as yourself. This is not a law-making facility. That's what we have people down in Cheyenne to make laws and statutes that govern the counties. The counties are not law-making facilities.
Correct.
So I think that we've got a law. We ought to abide by the law. Everybody ought to abide by the law, including Mr. Knight and each one of you and myself. So I think we ought to just drop it right now because this is not a law-making facility. Thank you.
John? Anyone else? Public comment? If not, gentlemen, I'm going to leave it up to you.
Well, I think I made my position clear. Under this NCU, Natural Expansion Doctrine, you know, there's a little bit more than a page I think the exceptions, the caveats, what's permissible, what's not, are pretty well straightforward. I didn't
What I
have any
thought.
problem with this.
Okay.
So my opinion is let it leave be. I see no reason for change. I think both the county and the public can be protected by keeping this clause in adequately. That's my 2 cents.
Okay. Mr. Knight?
Just to regard whether or not this is confusing, or maybe it contradicts itself numerous times here. And in one example,
What is your opinion?
Section F, the test used to determine whether a proposed use fits within an existing non-conforming use. Well, a proposed use cannot be an existing non-conforming use. I mean, the proposed use is automatically disallowed under this test. Then the next one is factors to be considered. But it doesn't say factors to be considered for what? Whether we're talking about, I have no idea what that means.
The future one that you're talking about, or the existing one?
And then it says that the addition or substitution of new or impermissible uses is prohibited. Well, it's already said over here that this only depends on, it only pertains to uses that are already, so that's redundant at best. And again, there's not a mention here of business use. And that is, and I read from the legal encyclopedia that this is only applied to business uses everywhere else. So the choice is, do we have it at all? And if we have the natural expansion doctrine, which most jurisdictions don't, those jurisdictions
That's not correct.
all limit it to the business use. And we don't even do that. So I would disagree that it's not confusing and it's an easy test to apply, because we've spent, me and lots of other people have spent many hours looking at it, and we're not sure what it is.
Chairman, yes, sir.
And maybe we do need to hire somebody else to figure it out.
Yeah, maybe.
Go ahead, Al. For me to better understand and have an opinion on a vote here, I'm curious, how does this end up in front of us? How does it get on the county's radar that we need to consider this?
No kidding.
Jones case.
They're mad because we won.
The court said that they had a non-conforming use. No question about that. And under our liberal interpretation of the natural expansion doctrine, it applied to them, whereas normally it wouldn't have applied.
It's personal.
Mr. Chairman?
Sure.
Are you done?
Oh, by the way, this would not affect the Jones property, even though it's personal against the Joneses. That case is decided, so this would.
Well, that's what I have a question about. That case was decided in the Trona County District Court.
It was.
Did not go to the Supreme Court.
No, it didn't.
Not state law.
No.
Okay. I think, Mr. Chairman, we're talking about lots of different things here, and see if I get confused about a lot of them. But we have non-conforming uses.
Yep.
We have grandfathered type stuff, which could be a non-conforming use, could maybe not.
No grandfather.
But it leaves everyone to have to go to court to prove that.
That's the same.
Yeah, well, it wouldn't be grandfathered if you were conforming when you put the things on, when the zoning on it. We have zone changes, which can happen. And we have, the personal property rights that everybody talks about.
Correct.
All of those are a little bit different. So if does this, Mr. Knight, I guess to you, does the natural expansion doctrine, in my mind, only speaks to that? Only the one narrow thing that we're talking about tonight is this natural expansion doctrine. I would disagree with the gentleman that says that the county can't make laws, because we make rules and regulations, or whatever you want to
Which
call
are
them.
ordinances.
I think you have the ability to do those things for the public benefit. etc., which are laws or rules and regulations, whatever. They're enforceable type of things. If we're going after just this one thing,
You'll find yourself
is it
in a
gonna,
lawsuit, what you're gonna
and
find.
it's very confusing now. Will this clean it up? And the other question, this came from the county commission as a result of the Jones case,
Yep.
basically. And to fall in the line with the general, we'll call general law of the land across the land.
I haven't heard a word from you.
Very confusing.
What would you guys like to do?
Well, I think we need to make a motion. And as we usually do, we do it in a positive sense and then let the chips fall on our vote. So I would move that we approve the proposed resolution as presented by staff.
Okay.
Second that.
We have a motion to approve, and we have a second. Is there any more discussion? With that in mind, then all in favor of this motion signify by saying aye.
Aye.
Aye. All opposed, same sign?
Aye.
I shall abstain. I don't know enough about it to vote one way or the other.
Okay, we have 2 for, 1 against, and an abstention. With that, the motion carries.
That's a shame.